This week in EDU 503, I decided to discuss Franklin versus Gwinnett County Public Schools. Facts of the case. The case Franklin versus Gwinnett County Public Schools reached the Supreme Court on December 11, 1991. Justice Brian R. White delivered the opinion of the court. Christine Franklin was the plaintiff, and Gwinnett County Public Schools was the defendant. Facts of the case continued. Petitioner Christine Franklin was a sophomore at Gwinnett County Public Schools in Gwinnett County, Georgia. Christine Franklin claimed she was subject to sexual harassment and abuse by teacher and coach Andrew Hill between the years of 1986 and 1988. According to Franklin, Hill engaged her in sexual explicit conversations, forced kissing, and conceived intercourse on the school grounds. Franklin stated the teachers and administrators were aware of the sexual harassment, and no one put a stop to Hill's inappropriate behavior, and even discouraged her from placing charges against Hill previously. Franklin claimed other students were also victims of Andrew Hill's sexual actions. Facts of the case continue. Gwinnett County Public Schools decided to launch an investigation over Franklin's statement, but closed the investigation when Andrew Hill resigned on April 14, 1988, under the condition that all matters pending against him be dropped. After the resignation of Hill, Franklin brought the case before the federal district court. Franklin sued for monetary damages under Title IX of the Civil Rights Acts of 1964. Title IX states no person shall, on the basis of sex, be excluded from participation, be denied the benefits, or be subject to discrimination under any educational program or activity receiving federal financial assistance. The district court dismissed the lawsuit, stating that Title IX did not allow monetary relief or damages, and the U.S. Court of Appeals of the 11th Circuit affirmed. The case, Franklin v. Gwinnett County Public Schools, ended up going all the way to the Supreme Court. Arguments. Christine Franklin, plaintiff, argued that she deserved monetary damages under Title IX of the Civil Rights Act of 1964. Franklin felt she was discriminated against with the administration knowing of Hill's sexual harassment and not stopping the inappropriate behavior immediately. Gwinnett County Public Schools defendant argued that an award of damages violates separation of powers principles because it unduly expands the federal court's power into a sphere properly reserved for the executive and legislative branches. Court findings. The U.S. Supreme Court came to a unanimous decision, 9-0, led by Justice White on February 26, 1992. The students who were victims of sexual harassment in public schools can sue for monetary damages on Title IX of the Federal Education Amendments of 1972. The 11th Circuit decision was reversed and remanded. The Supreme Court's ruling was important because before the case of Franklin v. Gwinnett County Public Schools, the damages weren't paid under Title IX. Court findings continued. The Supreme Court justices stated that Title IX only allowed for back pay or the violation to be resolved, so Christine Franklin actually wasn't awarded any settlement from the Supreme Court. Franklin was no longer a student at Gwinnett County Public Schools and could not receive back pay, and the initial threat had ended with Andrew Hill resigning. Christine Franklin ended up settling outside of court for an undisclosed amount. Implications for the Athletic Activities Administrator. 1. Administration should make sure faculty and staff members complete sexual harassment training on a yearly basis. Harassment training should introduce signs, protocols, and how to report suspected harassment. 2. Administration should always make sure students learn about harassment and how to report it to administration or counselor if they feel they are being harassed by another student or faculty member. 3. When allocations come up, administration needs to take all reports seriously and open up an investigation, making sure the student and student bodies are safe while building trust with the student body for future potential issues. 4. the administration should try to resolve all issues in a safe and timely manner and receive help from local police if needed. References: